All right, we're back for episode 3 of unCOMPlex, and I'm going to be watching the chat room for questions. And a primary purpose of our being here is to answer questions and to try to deal with issues. I'm happy to answer questions you might not want to ask elsewhere, and I'm happy to take questions that you want addressed by email or snail mail if you want to send them in. My contact information is pretty well known out there, I think. But you can always hit me at david.langham@doa.state.fl.us, and that's underneath my picture on this podcast. So hopefully that's viewable for you and obvious. You are also welcome to give me a call. My telephone number is 850-806-0420, and you can reach me on that or leave a message, and I'll be happy to take your questions that way as well. What have we got going on this week that is worth noting? I had somebody ask me about how you can reach the recordings of this podcast and other things. If you go to our website, you will see right on the front page links to the blog right here. And if you go to the announcement blog, you will find data about what's going on and what's important in the world of Florida workers' compensation litigation. And hopefully we'll try to keep you up to date on what's going on outside of litigation. So for that, I recommend that you click the regulatory news blog, and that will give you an idea of different things that are going on around the state that may not have to do specifically with litigation, but more the way things work. So the announcement blog is important because it tells you that we've got the meet and greets coming up in Miami and West Palm Beach at the end of this month. That'll be on the 28th in Miami, the 29th in West Palm Beach, both at lunchtime. The Florida Bar Workers' Compensation section is sponsoring those events and is providing lunch, but they do need a head count. We need to know who's coming so that we can do what we can do to make sure that there's enough sandwiches and soda and that sort of thing present. So if you're going, you can contact Paulo Longo, who's the chair of the section. You're welcome to email me if you prefer, and I'll help him with accumulating names and reservations so that we can assure ourselves that there's sufficient capability there for the crowds. What are you going to have the Somebody had a question. Is that a question or was that a bad mic? I'm going to assume it's a bad mic, and I'm going to keep rattling on. If it was not and you have a question, hit your chat room, and we'll be happy to take any questions you have. I'm watching the chat room. So what would you want to come to those meetings for? Well, for one thing, if you have not met our new director, Judge Darren Schwartz, he will be at each of those meetings, and you get a chance to talk with him and listen to him about what is going on, at least from his perspective, the broader spectrum of the Division of Administrative Hearings and what they are up to. That's a pretty good opportunity. I would recommend it for that, if for nothing else. You can also, on this blog, the announcement blog, get to the episodes of the unCOMPlex blog, podcast rather, and listen to it. We'd be grateful for you to pass the word amongst your friends, and we're going to do some things to promote that at other events coming up. What other events are coming up? We've got in April, the Workers' Compensation Forum, 17, 18, 19, down in Orlando at the wonderful Champions Gate Resort. And they host that event. WCCP and the Workers' Comp section, I think, both do an exceptionally good job of putting on an educational program. Some highlights, though, on the 17th, Wednesday evening from 6:30 to 7:30, there is a reception in the Osceola lobby area. And in addition to that specific event, we, the OJCC, are also going to be there an hour prior to that. And we're going to be hanging out in that Osceola area, judges, mediators, and we would love to meet with you, talk with you, give you a chance to meet folks that you've perhaps not met before except over a Zoom link. And I'd like to hear what you're thinking about and what you think is important in workers' compensation. We are going to also already planning for the WCI program in August. That's 18, 19, 20, 21 of August. We will again have our opening night meet and greet special at that. That's on Sunday the 18th. It will be in 3 rooms in the Hall of Cities, and we'll put that news out on the blog as we get closer and confirm that room assignment. If you weren't at the one last year, I've got to tell you, we must have had 250 people come out. It was absolutely crammed. It was a fantastic opportunity to meet people, to catch up, and in a post-COVID world, to have a chance to shake hands and actually get to know somebody. So I really encourage you taking advantage of those opportunities and coming out and seeing us. We'll continue to podcast on the second Wednesday of every month and try to keep up with that. In October 18th, we've got coming up the next edition of the Workers' Compensation Academy for the Office of Judges of Compensation Claims. And that is intended for younger lawyers. It's not an age thing. It's folks who have been practicing in workers' comp 7 years or less is the group we'd prefer to see. We will accept applications from anybody, but we're going to prioritize those folks that are younger lawyers who are trying to get some experience and trying to figure out what this practice means. It is too often, and I'll say that succinctly, it is too often that people assume that that folks that are really good in this practice got there the easy way or fell into it. It took a lot of hard work, and we have got some fantastic practitioners in this practice, and we get them out for those academy programs and get the younger lawyers an opportunity to meet them and glean from their knowledge and to learn from their mistakes. I'm proud of the program. Special thanks to Judge Pitts, Judge Kerr, and Miss Anna Gonzalez Fajardo, excuse me, down in Miami for all of her help in putting that together and presenting it. We've also got a fantastic steering committee, and we're grateful to them for their efforts putting that together and putting it on. This year, we're going to also launch what we're calling a Certified Scholars Program, and that's going to be for lawyers who are nominated by one of the judges. We're going to have a very limited, small scope educational program. More details on that will be coming out in weeks to come. If you have an interest in that or any questions, you're welcome to send me an email. And again, my email is on the screen. The other thing at the forum that I meant to mention, I'm sorry, is that we're going to have the nominating commission meeting at the forum this year. And that's your opportunity to see these judges interview for reappointment. Judge Anthony, Judge Medina Shore, Judge Weiss, Judge Grindle, Judge Mooneyham, Judge Clark, Judge Johnson, Judge Hedler, and Judge Walker here in Pensacola. What does it take to be a judge of compensation claims? The statute really says that you're going to be a member of the bar. You're going to have 5 years of experience in workers' comp. And we've had a lot of people ask us, what does that 5 years of experience mean? Well, I got a great answer for you. I don't know, but you make the case. If you'd like to apply for a judgeship and you think you've got that experience, well, tell us why you think you've got that experience. If you'd like to pick my brain about whether your particular situation meets the qualifications, reach out and I'm happy to discuss that with you. Not because we've got an opening today, folks, but because openings will periodically arise. I can tell, and you can tell just to look at me, that some of us are aging. And we're not going to be around here forever. And we've got to figure out a way to get younger people invested in our side of things, the adjudication side. And so we're happy to answer your questions anytime about that process. We've got a 16-member commission now. That's because we have a member from each of the 6 District Court of Appeal jurisdictional areas nominated, appointed by the bar. We have one from each of those 6 areas appointed by the governor. And then those 12 people have appointed 6 others that are members of the public. And so 18 people. Another thing you might not think about too often, but boy, put this in the back of your head. That's 18 people that would be excellent to talk to about what you think about workers' comp and about questions or issues you're having in workers' comp. They are folks that have been around and really understand our system and understand the adjudication process, and they would be great brains to pick. We'll be there Friday morning of the forum with the nominating commission, and that date again will be, what do we say? The 19th of April, that Friday morning. We'll be done by lunchtime. So even if you're not going to the forum, you're welcome to come out for that meeting. We'd love to see you. What else does it take to be a judge? I recommend working on board certification. I recommend building your experiences and your abilities, and I recommend picking the brains of those around you. There's not anybody that's going to be at the meet and greets at the forum from our office or at the meet and greet at the WCI that wouldn't spend 10 minutes talking with you about your aspirations and your questions. So come on out and talk to us about that if you would like. We would love to hear from you. And you can email me if you'd like to talk to me personally about it. Happy to do it. That's what's coming up. We're just coming off of the big program we put on March 1st at the First District Court of Appeal, and it was a phenomenal program for the most part. I say for the most part because there's going to be ups and downs, but we've got those all recorded, and on my production schedule, I have got us lined up to push those recordings out. We're going to start on looks like on March the 25th, we're going to load one of those recordings, 1 hour of programming, to our YouTube channel. If you didn't know we had a YouTube channel, you should be getting these email blasts from me. And in the email blast, we've got links to the podcast. That will take you right there, straight to the YouTube channel, and you can pick up and listen to these podcasts. You can also find any number of other fantastic items out there that you might want to look at from that programming in Tallahassee or otherwise. There's a great piece on there that I did on the history of the Code of Judicial Conduct you might find of interest. Lets you know how judges might perhaps ought to behave, and maybe help you understand instances in which they didn't behave quite as we might have hoped that they would. Joining us now from Tallahassee is Miss Givens, who was my very first podcast attendee. Thank you for being here, Miss Givens. He's probably thought I'd forget that. I never forget that. You never forget the people that support you, and that's important. We want to support you too. So again, come out to these functions. Let's talk about things. What's going on in the world of workers' compensation? I sat and had a chance to chat with a judge at the program in March. And as this judge described to me a recent trial, there was not quite a cacophony, but certainly some level of support and me too going on in terms of their perceptions of lawyers struggling to make evidentiary showings, to lay evidentiary foundations, if you will, and get evidence admitted in trial. The story that was related was about a lawyer who was attempting to authenticate medical records, okay, and to at the same time get over an evidentiary objection based on hearsay to get those medical records in evidence. The lawyer took a run at it and drew an objection, took one more run at it and drew another objection, really couldn't make an argument except that in this lawyer's opinion, those documents were what they were, and that should be good enough for the judge. And I'm here to tell you that wasn't good enough for the judge. It's not going to be good enough for any judge. What do you do to successfully try a workers' compensation case? Well, if you want to talk about authentication, I suggest you look at Muhammad versus Dodge. Okay, why on earth do I have Muhammad versus Dodge? I didn't look I've got no notes. Where am I getting that? Well, I've cited that case 1,000 times. When I was practicing law, I had an exception to the hearsay rules. I had an exception case on Section 6 of 803. Okay, and I had that cited in a notebook. Just a plain legal pad that I would take with me to hearings. I kept it in a file folder in my office. It was my trial notebook. If you build a checklist, if you have resources at your fingertips, you're going to be one step ahead of your opponent. There's a really horrible old bad joke about these two fellas that are walking through the woods, and suddenly they're confronted with a bear. You've probably heard this story. One of the gentlemen sits down immediately, begins unlacing his boots, and he's got his tennis shoes pulled out of his backpack. The other hiker standing there looks down on him and says, "You You idiot, that bear can run 35 miles an hour. There's no way you can outrun that bear. And the guy on the ground putting his tennis shoes on looks up at the guy in his hiking boots and he says, I don't have to outrun that bear. I just got to outrun you. And folks, that's what trial practice is. You may not have the very best authority for why a business record should be admitted, but if you've got better authority than your opponent, you're one step up. And if they choose to come to trial in their hiking boots and you choose to come with your tennis shoes, there's a pretty good chance that you can outrun them. And that's what you're trying to do. It's a competition. It's a trial. Make a note on cases that you think are helpful. If you're practicing any kind of law and trying cases, you're going in front of a judge and you don't know Binger versus King Pest Control, you're in trouble. I won't tell you what Binger stands for. You should go look it up. Okay? These are cases you should have on a list that you can go to, a list where you can give the judge something. And when you've got nothing, when you have absolutely nothing to throw on the table, folks, the way to try a case is A, with sincerity, look the judge in the eye. 2, with humility, admit to the judge that you don't have an answer to the question. And 3, resourcefulness. Ask the judge if you can have 10 minutes to sit down and check on your iPhone or to call somebody back at your office to do a quick Westlaw or Lexis search. Ask the judge if you can submit some post-hearing legal argument. Okay? I'm not saying these are going to be things that will be granted by the judge, but why would you not ask? Why would you throw up your hands and say, well, judge, I guess I don't have a response to that objection, so I guess I'm done with this witness? Well, you called the witness for a reason. You've got the judge wondering what the devil that witness was going to bring to the table, and you've left a hole in your case. And that's going to be hard for you to get around and to explain. It's problematic. It's troublesome. I heard a story about an airliner out in Oregon or Washington lost they call it a door plug. And so this airplane's at 17,000 feet and the side of the airplane comes loose. You've probably read about this in the news. What a lot of the stories didn't cover was that there's a switch, a safety device that when you lose cabin pressure in an airliner, that cockpit door comes open. I'm not sure why they want that, but that's the way they designed it. Well, when this aircraft emergency happened a couple months ago, that door popped open on the cockpit and the suction pulled a lot of paper and things out of the cockpit. Now, the pilot, who's been flying for years, thousands of hours, is suddenly without these papers. But you go looking for this, and the story says that she reached down beside her seat in her bag, and she pulled out a copy of the emergency checklist for that aircraft. She was prepared. That book that you're talking about was probably in that bag week after week, month after month, year after year. She probably drug it around 100 airports without ever needing it. But when she needed it, when the plane decompressed, she had that to pull out and to go down that procedure checklist. I don't care how many thousands of hours you've got. I don't care how many trials you've got. Build yourself a checklist to remind yourself of what you need to do each time, every time. Within the last couple months, I had a story related to me of a lawyer that took a deposition, a beautiful expert deposition, never asked the doctor whether she held those opinions to a reasonable degree of medical certainty or probability. Well, folks, that kills the testimony. I'm not saying you can't use it. I'm saying you're going to have trouble using it. You're going to have trouble making it persuasive. If you had a checklist for your depositions, it would remind you that when you get finished, you need to ask that question. It would remind you need to ask every time whether the witness wants to read or waive. You want to get those pieces and you want to remember them every time. If a pilot can't remember everything and is going to use checklists, why not us? Trust me on this piece, the older you get, the harder it's going to be for you to remember things. And the harder it is for you to sort of process and keep moving through. Another interesting piece that we saw just this last week was another sanction, this time from the federal courts. I can't personally believe that this is going on, folks. The fact is, it just simply astounds me. But a lawyer down in Southeast Florida was called on the carpet by a federal judge because some documents were filed that cited cases that did not exist. And it turns out that the lawyer engaged in the use of artificial intelligence. Great punchline to that joke a friend of mine delivered in a webinar here in December was that he thought all intelligence was artificial. And that's funny, but if you're using AI in all seriousness, you cannot trust what it puts out. You have to verify it. The Florida Bar has recently issued their opinion on the appropriate use and the appropriate cautions with artificial intelligence. Watch for your News in 440 report. There's a wonderful and short article outlining what the Florida Bar has decided to do that'll be in the next edition this spring, written by a young lady named Sydney White. And it's a fantastic opportunity for you to sort of catch up on the AI. But what's the downside? This lawyer finds himself now suspended from the practice in the Middle District of Florida. I've never understood the Middle District of Florida. Just as an aside, anybody that tries to explain to me that Fort Myers and Jacksonville are in the middle of Florida has got an uphill road of hoe. Now, I'm not saying you can't convince me, but that doesn't seem very middle to me. But that's the way the federal courts have divided up the state. And so this lawyer's not going to be practicing in federal court from Jacksonville down to Fort Myers. That's bad enough. Worse? What's worse than not being able to practice in federal court? I would suggest to you that the publicity is probably worse. That publicity is not going to do that lawyer or his firm, her firm, I'm not sure, any favors. It's going to be damaging. The young man that had problems out in New Mexico that I mentioned in previous presentations, when he found out that he was dealing with citations that were hallucinated, he doubled down. He doubled down and told the judge that it was someone else's fault, that he didn't know, and it turned out that wasn't true. Now he finds himself suspended from the practice of law after all that investment and time. You really should remember that the rules regulating the Florida Bar require candor with the tribunal. And you'll never see me wearing a robe. You'll never see me swinging a gavel. But if you're in a proceeding, I'm the judge. And that makes me the tribunal. And so I expect you to tell me the truth, and I expect to tell you the truth back. We're not in trial to hide things from one another. We're in trial to get it out on the table and get a decision made on the merits of the case. That's not to say your evidentiary objections aren't palatable or usable, but boy, don't double down on dishonesty. Years ago, there was an instance where a lawyer was caught in some misstatements and received a merits order in the mail, noting those misstatements and making a credibility finding based on them. And you'll never believe this, but that lawyer filed a motion for rehearing. And the basis of the motion for rehearing was that the judge was demeaning that lawyer's professional credibility. I won't argue with you about whether it demeans your credibility or diminishes it, but I would suggest to you that that's not the judge's fault any more than the mirror is the fault in the way I look. I look in the mirror. It ain't the mirror's fault, folks. I really look like this. That's scary, but that's the truth. Don't take the reflection as problematic. Other things that are going on that are intriguing in workers' comp. We continue to have a fair amount of mismatched documents being filed. When I say mismatched, what do I mean? The motion for approval of attorney's fees said that the attorney got $14,000 in benefits and is taking an X dollar in fees. Well, the fee data sheet says they got $12,000 in benefits and they're taking Y dollars in fees. That doesn't make any sense. We all know that probably there's some degree of the work in your office that's being done by paralegals. You may be delegating it to associates. But that's no different than artificial intelligence, folks. That work, if you're going to put your name on it, when you put your name on it, you're telling me that what's in it is true to the best of your knowledge, to the best of your ability. That candor to the tribunal. Well, 14,000 is not 12,000 and X is not Y. And so one of those statements, perhaps two, perhaps all four of them, are not true. And that can be inadvertent. We all make mistakes. But it's no different than when you find the AI mistake. Okay, if you find a mistake that your paralegals made, own it. Own it, fix it, find a way to remedy it, and do so, as I mentioned before, with humility and with grace, and you'll go a long way. I've practiced law in front of a lot of judges over the years, and since I got this job, I've known a lot of judges, and I can tell you they are a pretty cerebral, pretty genial, and a pretty forgiving group. Not so much when you try to pull the wool over their eyes. But when you're upfront and you're honest and you're frank, you can fix a lot of errors and a lot of mistakes. I saw an instance recently where a series of emails went back and forth between lawyer and client. Boy, why am I seeing emails between lawyer and client? This is something that I would suggest to you as a really good topic that lawyers should revisit with their clients all the time. Anything that you send to the Office of Judges of Compensation Claims is a public record. And so if your client becomes perturbed and decides that they want to start sending emails directly to the other party or to the other attorney, you have the potential for waiver of privileges and immunities. Well, when they start copying the judge's office so that those end up in our inbox, from my perspective, folks, they're also going to end up on the docket 99 times out of 100, if not more. Clients don't seem to understand that. They oftentimes don't seem to understand, or they don't remember, that everything that was said at mediation was privileged. And they get these email strings going and they're dragging us into these communications where they talk about what their lawyer said or what they said to their lawyer. Now, once I get that communication, folks, like I said, it's going on the docket. They've breached that privilege, and they may have done so in a way that's offensive to the other party, or at a minimum is damaging to themselves, and they did it through a sense of ignorance or through a sense of frustration. I can't ask you more sincerely to counsel your clients and talk to them about the perils of disclosing private information. I would ask you to remind them that if they ever get the urge to send us an email, they might want to text you or call you first and give you a chance to talk them in off the ledge. A lot of those emails I get from folks come in at 2 and 3 o'clock in the morning, and I'm up. It doesn't bother me, but I sort of cringe because I feel like somebody is maybe not getting enough rest. Somebody's maybe tired. Somebody's frustrated, and they're getting themselves or their entire case into a situation of peril. So I would caution you against it. In that same regard, I'd caution you to be aware and careful of what your staff is doing in terms of your clients. Are they discouraging those kinds of outbursts? I would hope. We have a lot of lawyers that don't really want anybody talking to their clients, and that's certainly between client and attorney. I get that. But when the relationship deteriorates, when there comes a separation, it would be really, really helpful to the Office of Judges of Compensation Claims, particularly if the claimant's lawyers, upon that divorce, would pass on to the injured workers that they can become certified full access users of the electronic filing system, and encourage those clients, because they might not get another attorney, encourage them to get registered. That allows them to send and receive documents. It allows them to keep up with their case in a much, much simpler way than the post office and paper. And it's a very big benefit to your former client. Why not help them? Why not sort of point them in a direction that eases them down the road in a way where even if they're upset with you or you're upset with them, they can walk away feeling like you still are looking out for their best interest and you're trying to help them. I think it's extremely important. And the same goes for employer carriers. I've seen those relationships break up as well. And some of those folks that I had issues and challenges with over the years were folks that I was doing a very little bit of work for. They were out-of-state carriers or disconnected from the situation in some way, like an unrepresented employer, uninsured employer. In today's world, telling those folks that they can get access to the litigation is really important, and I think it helps you. Oh, I seem to get no questions. Nobody's ever interested in anything. And so on I go, rambling about workers' comp from my perspective. I got at Tallahassee. Somebody had seen the podcast, and they asked me where I got the fancy backdrop. This is not a backdrop, folks. I kid you not. From a historical perspective, I'm gonna show you this. These right here are called books. Books. They're full of knowledge. Books. And the reason I wanted to point it out to you is because lots of people know about these books. You may have seen these in some of our district offices. This is decisions of the Industrial Relations Commission. The Industrial Relations Commission was created in 1978, and they were, in a lot of ways, in charge of workers' compensation, specifically in terms of appellate practice. That was back in the days, 1968, before the First District Court of Appeal became involved in workers' comp appeals. And so all of the decisions that were appellate decisions went through the IRC, the Industrial Relations Commission, and some of them ultimately went to the Florida Supreme Court. And those opinions you'll often see cited in First DCA and Supreme Court opinions. And you may find yourself asking, well, it's all well and good that these things exist, but how on earth would I ever access them? And so I just wanted to show you today on our resources page, okay, we have got copies of the statutes going back. We have got access for you to all of the rules of procedure. And if you dig a little bit, okay, nope, not on this page, but if you go to the orders page, okay, you can search our final orders by keyword, and you can get the IRC orders by keyword. And if you've got a specific one that's cited in a case, you can put the number in there and you can find that IRC order, and you can get a better idea of where they were going. Ms. Given says, other than gathering cases as we practice, any recommendations for places to look when making our list? Oh my goodness, you're going to hate the answer to this question. The greatest teacher I ever had, Ms. Givens, was failure. and that's horrible. But you're going to make mistakes, I think. Maybe not. A lot of folks are a lot smarter than I am. But I made a lot of mistakes, and every time I made a mistake, I would add something to my list so that I didn't get caught in that mistake the next time. The cases that I really fell in love with, like Binger, I would put those with my legal pad in a folder and put a copy of Binger behind it. Put a copy of Dodge behind it so that I had those at my fingertips. They're not always going to apply, okay? Boy, I'm not telling you to mislead anybody, but if you've got nothing else and you're sitting there with Binger, you got no other argument to make the catch-all 807 argument, okay? And throw Binger at the judge and say there's no actual prejudice, right? Even if everything they're saying, Judge, is true, you should still let this document in under the catch-all. And look, there's really no actual prejudice. Maybe there is, maybe there isn't, but at least you've then put the shoe on the other foot, and the other side's now got to come forward and demonstrate prejudice. Many a lawyer has been flummoxed by the fact that there has to be prejudice. And if you can't demonstrate it or enunciate it, well, that objection might go away. You know what comes up in case after case. My goodness, hearsay, authentication. Understand those are not the same things, authentication and hearsay. They have some common elements in terms of your response, but put a case for each one in your folder. Somebody asked me last month if they could watch trials that others are participating in. If you send me a request and tell me you'd like to see the video for a trial that occurred on such and such a date, we'll get you access for that. I'll get you a copy. We're actually working on trying to give you better access to information on our website. We're going to try to add legal assistant or judicial assistant names and phone numbers to give you easier contact. We're going to try to add the judge's Zoom links so that you have it there instead of having to look at the notice. We're going to try to look at a variety of different things. And one that we're talking about is trying to get some live video stream so that you could tune in and watch what's going on in any judge's hearing room at a given moment. The technology on that is a little dicey and a little spotty, but it's something we're thinking about. Where can you glean these ideas to put in your checklist or your folder? The next best thing to making mistakes is to listen to what other people have done that didn't work out for them. We won't call them mistakes, but boy, going to the ends of court meeting and shooting the bull with people that have tried cases, okay, will give you the opportunity to hear war stories. Understand that when people tell war stories, they're always going to be about them winning, right? They're never going to tell you they were the one on the short end of the stick that didn't have an answer or didn't know the solution. They're going to tell the story like they knew everything. But what you glean from that is that, hey, that's something I might need to know. And you go back to your office and spend 10 minutes on the internet, find a case, stick it in your notebook, okay? I was talking about these books. This is the one. Some people, the IRC, like I said, 68 to 79, okay? There's still people practicing that remember the IRC. Nobody, I can't find anybody that remembers this bunch. This is the Florida Industrial Commission. The FIC was before the IRC, and the FIC had commissioners, and they were also the appellate authority for workers' compensation. So from 1935 to 1968, you have these cases that look just exactly like the Southern Second, but they're the FIC decisions. Why do I point it out to you? I don't have these online, but the IRC you can get on our website, just like looking up our trial orders. And the FIC, you'll find that law school libraries have copies, as well as the archives in Tallahassee. And if you're in a real pinch, I've got 2 sets here. Don't make me do all your research for you, but if you really need one, send me an email and tell me that you need a copy of such and such, and we'll make a copy of it for you and shoot it out. These are great resources. They're things that you need to know about and to study at least a little bit. I am on the right track to find lots of cases. Boy, that's not very nice. I'm sure you don't make near the mistakes I make. What time is it? It is 12:40. I've made 17 mistakes this morning already, 3 of them horrible. So, if you're feeling like you're in left field, you're not. We all make mistakes. Getting through life successfully is not about avoiding mistakes. I'm not saying you shouldn't try, absolutely. But the key is not in preventing falling down. The key is in finding a way to get up and getting up in a way that allows you to move forward and make the next decisions. Your law firms, they owe you the opportunity to make those mistakes. You need to go out. You also need to find somebody down the hall whose door you can go darken and say, I've got a problem. I need to pick your brain. And if you don't have that person in your law firm that will be a mentor to you, you're welcome to email me. I will find you a mentor, okay? If you just need specific advice, Paulo Longo and the workers' comp section have built a database of folks who have various expertise And so you could contact him and say, Paulo, I'm an attorney, do workers' comp. I need some help with, pick a topic, hearsay, evidence, admissibility of expert reports, whatever it is. And Paulo can probably refer you to somebody that would spend 10 minutes and talk to you and talk you through, talk you back off the ledge. You're going to make critical errors, but mentoring is huge, huge in trying to avoid those and work through them. Crazy things that happen in trials. Young lawyers don't like this idea. I get it. I'm not sure I would have the guts to do it either. But I practiced against a young man back in the day, and he sort of threw me because every time we tried a motion or a trial, when I'd get up to leave the room, he always hung back. And I always wondered if he was having an ex parte conversation with the judge. Finally, one day I said, "Do you mind if I stick around?" The judge says, "No, certainly, have a seat again." And they went through this sort of ritual where the young lawyer asked the judge, "How did I do today? What could I have done different? Did I say things that I shouldn't have said? Did I do things that distracted you?" The lawyer was inviting criticism, was inviting growth, and that judge was willing to give that young lawyer some advice. I gained from the fact that I hung back that day. I found I didn't have time to do it often. There's nothing wrong with asking a mediator. I kind of got lost today in that mediation. Where did I go wrong? Call the other lawyer afterwards and say, can I take 10 minutes of your time? I don't like the way that mediation went. I felt like I was off key or off guard. Do you have any advice for me? And the fact is, in this practice, we all see each other time and again. You're going to run into a lot of people that'll take 5, 10, 15 minutes, and they'll tell you what you can do better. And if you'll listen to that, you will grow, and then you don't have to make the mistakes. You don't have to do the things that they've done, and you'll get better and better at what you do. And always the rule is practice and play against people that are better than you. If you want to be a good tennis player, go play one of the Williams sisters. Don't play tennis against me. That's not going to make you any better. I'm not going to challenge you. Okay. But if you're going to try cases, figure out a way to go try one against Mark Tobey. Okay. Try to find a way to go try one against Glenn Whelan. And those people that have been around and know the trial game, they will teach you things. Sign up for the DOA Trial Academy. I think I've got that on my calendar. The DOA Trial Academy, sure enough, is September 16th through 20th in Tallahassee. The cost on that is free. It's underwritten by the administrative law section, and you get to try a case over and over again over 5 days, and you'll learn a lot. Coming up in May this year, the workers' comp section has got their trial program. That's down in Miami in May on the 17th and 18th. And I'm looking here, I believe that they're full for this year, but they'll have that opportunity again in the future. Those things help you a great deal in terms of walking through process and learning. What else is going on in the world of workers' comp that's worth mentioning? You cannot change people's testimony. Now, we continue to have a problem with this, and I know folks are probably tired of me saying it, but I'm going to keep saying it till people quit doing it. If you send an affidavit to your client, I don't care what the affidavit's about, affidavit means evidence. You're gathering sworn testimony from a party or from a witness, and then you're sending that sworn testimony into the judge's office. And if the judge has a question or a problem with it, where that affidavit needs to be redone, no, you cannot just white out that document that you have and write in changes and then file it back with the judge's office. When you do that, you've changed the substance of the witness's testimony. And you've done it without us having any indicia that the witness knows. And you say, well, yeah, but I talked to my client and she said that I could change that. But her initials aren't there to signify that to us. She's not re-signed it. It's not been re-notarized. And so you're going to create an aura of doubt in the judge's mind as to whether you've actually contacted the client or whether expediency is getting the best of legality. That is going to damage credibility, potentially, maybe probably, and you're changing somebody's testimony. Would you do that with a deposition? Would you sit in your office as a lawyer and mark through the words in somebody's deposition and add new words and then file it as if it was their testimony? I cannot imagine that there's a lawyer out there in the listening audience or in the world that says that they would do that. The ones that would do it, I don't think they would ever admit it. Fact is, it's wrong. It's inappropriate. We can't have that going on. But time and again, we just keep seeing it. It's getting kind of frustrating. Nobody else has any questions? Can we get anything in the chat box, or are we going to wrap this one up early today? I'm not seeing anything in the chat box. I could tell jokes for about another 4 minutes, or we can pack it in, and my jokes are, frankly, pretty horrible jokes. So we won't go there. If you don't know, you talked about your recommendations. If you don't know how to tease out the predicate questions on authenticating a document or on overcoming a hearsay objection, really all you have to do is go to Westlaw or Lexis or the free one through the Florida Bar, the name of which I can't remember right now, and simply put in the rule number and the word foundation or predicate, and you'll find cases where an appellate court has explained to you what 6 questions you're supposed to ask to authenticate a document. And very, very simple. So no questions. We're going to wrap up. I hope to see you all at the forum. If you come to the forum, I really would enjoy meeting you face to face. I'd like to see you at the Workers' Comp Institute. Not going to be at the FWA this year, but there are other events that are going on around the state, like the meet and greets. Any of those you can come out to. I sure would like to see you face to face, and I'd love to hear your questions, your issues, and your problems. Send me an email if I can help you on the next podcast. We will be back here, believe it or not, in April, on April the 10th, and before then, you'll see announcements on social media with the videos from the program at the First ECA. So thanks again for tuning in, and we'll see you all next time. Thank you.